Hi, everyone. Good morning. First day of 2024. My name is Ophir Gutelzon, and I'm with Unacceptable. Thanks for joining in such a short notice. We launched this meeting yesterday, very after the Supreme Court ruling. For those of you that know me, again, Ophir Gutelzon. I'm in Palo Alto in California. And today, after almost a year that we were, since Yariv Levin announced judicial reform, or as we know it today as a judicial coup, we are back with almost closing a circle with the Supreme Court decision yesterday, the Israeli Supreme Court. And today, joining me from Tel Aviv, Professor Yaniv Roznai. Yaniv is as an expert of constitutional law, an associate professor and the vice dean of Harry Redsner Law School at the IDC at the Reichman University and the Rubinstein Center of Constitutional Challenges at the Reichman University, and a member of the Israeli Law Professors Forum for Democracy. And thank you, Yaniv, for joining us.
Thank you for inviting me.
We are sitting. We are going. I'm going to. Yaniv's bio is much longer than what I shared. So Galit, who has joined me.
Phil, you muted yourself. Unmute.
I muted myself. Now you can hear me. Thank you. So links will be shared on the chat. Also on the chat, it's currently only the hosts are seeing the chat to make it easier for everyone else who is on the call. So send us questions that you have to Yaniv that we will start picking up later at the conversation. So we are almost exactly 24 hours after the dramatic decision by the Israeli Supreme Court to strike the reasonableness doctrine, cancellation of the reasonableness doctrine by the Knesset. I wouldn't want to ask Yaniv, first of all, again, we are still during war time as well. So how are you doing? And are you in Tel Aviv now? Nope. Unmute again. Here you go.
Hi, yes, yeah, hello everyone. Yes, I'm in Tel Aviv, so I think the usual disclaimer applies. In case there are sirens, I would have to leave my apartment and run to the shelter. So
your post.
Yeah, so do excuse me if this happens. Yeah, so we're still doing war, and it seems a bit bizarre to talk about reasonableness and the Supreme Court and doctrines. I mean, who cares when we have all this devastating news and we have another crisis coming with the ICJ. But it is what it is. The judgment was delivered yesterday. It wasn't actually a matter of any discretion of the court, because the court by law was obliged to publish it by mid of January. So we got it indeed yesterday evening. I have to admit, and forgive me, even I didn't get to read the entire judgment because it is well over 700 pages long. So it might take me a few more days to read it carefully. But I did gone over everything. And it is a really dramatic decision. And I think, thank you, Ophir, for organizing it, because I think it has some really important implications, both for the democracy in Israel, for the future, perhaps, of the so-called reform or judicial overhaul, and even some implications for the ongoing war. So maybe we'll talk about that as well.
And if you can remind, again, I know that many of the people that joined us knows what the judicial reform and what happened on January 4th last year, but maybe a short background of why we are sitting here after the decision of court.
All right, perfect. So if you all remember, exactly a year ago, January 4th, Minister of Justice Yariv Levin announced his so-called reform in the judicial system that included various reforms in the judicial system, limiting judicial review, enacting an override clause, changing the way judges are selected, decreasing the status of legal advisors to the government. And one of these proposals was the abolishment of the reasonableness doctrine, or in other words, to remove from courts the authority to review the reasonableness of the actions of the government and the ministers. That is basically the only part of the reform that was thus far enacted in July last year. And when this amendment, and this is again a constitutional amendment, and perhaps later we can explain the distinctions between amendments to the US Constitution and how it works in Israel, but this is a constitutional amendment, all right? So it's amendment to basic law of the judiciary. It was enacted in July, and following the amendment, there were various petitions submitted to the High Court of Justice petitioning against the constitutionality of this law, of this basic law, arguing that it undermines Israel democracy. And now we got this judgment, and I need maybe to say before that this is the first time in our history that the entire bench of the Supreme Court, all 15 judges, sat en banc to give this judgment. So this is quite unique, but it also shows you the importance of this matter, because it really is an extraordinary event. Now, the question that the court was actually forced to deal with is the following: whether this amendment to the basic law, whether it undermines the core values of the state as a Jewish and democratic. And why is this important? This is important because 2 years ago, in another judgment concerning basic law, the nation state, the Israeli Supreme Court has already held that the Knesset, even when it enacts a basic law or amends a basic law, cannot undermine the core values of the state as a Jewish or democratic state. However, in that judgment 2 years ago, the court left open the question, but what if there will be such a basic law? Can the court intervene? Can the court strike down a basic law that would undermine the values of the state as a democratic country? For example, the court never answered that question. And that is perhaps, I think, the big story behind the judgment of yesterday. Because yesterday what we got is that at least 12 judges, and perhaps also 13, depends on the interpretation, at least 12 judges out of the 15 held that the Israeli Supreme Court has the authority to strike down even a basic law. In other words, a chapter in our constitution, if it would undermine the core values of the state or the core features of the state as a Jewish and democratic. But this was the general decision. Now we get to the second question, whether this amendment that removed reasonableness, whether it indeed violates the core values to such an extent that justifies judicial intervention. And here the court was more divided. So out of the 15 judges, we have 8 judges who considered that the law is so violative of core values such as the rule of law, such as separation of powers, such as judicial independence, that we must strike it down. We cannot let it stay. So they completely declared this basic law as unconstitutional and void, invalid. In contrast, the minority or the dissenting judges, 7, consider that this is not the appropriate time to intervene in basic laws. Even though some of them recognize the general principle that in principle the court can intervene in basic laws, this is not the time to apply this, let's say, judgment day weapon, okay, of invalidating a basic law. But I also need to say something here. Out of these 7 judges, the dissenting judges, 3 judges say the following: we don't think that it is right for us to strike this amendment down, to invalidate it, simply because we can narrowly interpret it. So we can interpret the amendment that removed reasonableness as if it still allows us, the judges, to intervene in extreme cases. Let's say there is a really arbitrary decision or extreme unreasonable decision or a far-fetched decision, we can still intervene. Okay, so this is 3 judges. Why am I emphasizing it? Because in total, we have 11 judges out of 15 who say, look, we oppose this amendment in the manner by which it was enacted. It is harmful to our democracy. And this is crucial. So this is the judgment. And again, the main precedent that will, I guess, accompany Israeli democracy since yesterday for the next few decades, probably, is that the Israeli court can strike down a basic law if it would undermine the constitutional identity of the state. So basically, the court, the judiciary, is now the guardian of Israel's constitutional identity vis-a-vis possible constitutional reforms. And I think that this is crucial for the future of the reform. Because imagine, I don't know, we can talk about it later in the discussion of whether the coalition still wants to continue with the reform. We can talk about that. But at least in theory, let's assume that now the coalition would want to continue with the reform as it is. This would not be such an easy task as it was 2 days ago, because now they would have to pass another bar. And I find it a bit tragic in a way, because a year ago, Yariv Levin proposed in one of his reforms, he said, I want to remove courts' authority to review basic laws themselves. And this was actually unnecessary because the court never invalidated a basic law. The court never intervened in a basic law. This was unnecessary. But here, because of the last year and what we've seen, because of the extreme reforms that the coalition brought forth to the public, actually, this coalition pushed the court to the corner. The court probably didn't have any other way or not many more options other than striking down this amendment. So instead of weakening the court, we are closing a circle precisely a year later when the court is much stronger than it was a year before. And then not only that the court is stronger, but now the court has much more legitimacy from the public. So various surveys from the last few months have we've asked the public, do you think that the court should have the authority to strike down basic laws? Vast majority of the public said yes. An idea that was merely theoretical a year and a half ago. So I think the coalition brought this new constitutional revolution on itself.
So let's just go a little bit deeper. So we just need to remind ourselves. So there is currently a government that is 1 year old, 64 against 120. And so it's a slim majority. It's a majority that can actually make any law happen. And that's what we have seen. We have seen them doing a law and putting a title on it, which is a basic law. We're also going to remind ourselves that there is no constitution for Israel. I think that what you were saying, Yaniv, is that now the government, the court has agreed that even the conservative, what we call them, and we will talk about what is conservative and what is not, but even the conservative judges that was apparently appointed by Ayelet Shaked and others have said that the most basic document that everything will be supposed to be ruled by is the basic of the Jewish and democratic that is in the part of the independence, Declaration of Independence. And so I think that what you're saying is that, again, and just to clarify, basic law until now was a law that's supposed to be a pillar in our future constitution, right? And so what the court kind of like almost said, and you correct me if I'm wrong, is that this government is this random majority in the Knesset has abused the statement of what is a basic law, right? It's like you cannot just use it, but you can. I mean, and I'm happy to hear what you were thinking about it. But I want you, when you said that the court is now stronger. Is it true to say that the democracy is now stronger? Because we need to remember that the only check and balances on the government, right, is the court. So maybe you can elaborate on that.
Exactly. Thanks, Sophia. I think these are really crucial points. So to our American, I don't know, European audience, I don't know, but to our American audience, at least, I think it's worth emphasizing some of the distinctions between Israeli constitutional structure and the US one. So, you know, the US Constitution is probably the most rigid constitutional document in the world. It's almost impossible to amend the US Constitution. You know, for over 200 years, it has gone through only 27 amendments and only 17 amendments since the first 10 amendments, right, in 1791. So it only shows you how rigid this document is. In contrast, Israel is probably one of the most flexible constitutional orders in the world. Only in the last decade, we had more constitutional changes than the entire American history. And the reason to explain it is simply because basic law doesn't really mean anything process-wise. What do I mean by that? In order to enact a basic law, let's assume that tomorrow I want to enact basic law immigration. I can do that in a single day with a simple majority of, let's say, 2 versus 1 or 3 versus 2. There's no special process. There are no procedural limitations. There are no temporal limitations. You know, in Italy, if you want to amend the constitution, you have to wait a few months between the readings. In Israel, no, you can do it in a day or a day and a half. And there are no substantive limitations. So in Germany, if you want to amend the Grundgesetz, the German basic law, you can do that as long as you do not undermine human dignity, which is untouchable. But in Israel, there are no restrictions or limitations whatsoever. So the Knesset can basically do anything it wishes as long as it uses the title basic law. This doesn't make sense. This would actually give any political majority absolute powers of governance and omnipotent powers. We do not accept it in modern democracies or in constitutional democracies. So I think it is extremely crucial, especially in our structure, that the court has said that it has the authority to strike down basic laws. And I think here it's also important to emphasize also the importance not only of this judicial review, but also of the reasonableness doctrine itself. If you take Israel and you compare it to all other democracies in the world, in all the other democracies, there are various mechanisms of checks and balances and other mechanisms to make sure that governmental power is diffused and not centralized in one organ. So, you know, in the US, you have a presidential system with veto powers. You have a federal system with a vertical separation of powers. You have 2 houses in the legislature. In other countries, there are regional elections or subordination to European or supranational organizations or tribunals. There's only one country in the world without any such mechanisms, and that is Israel. All we have is a government, the executive, that controls the legislature, the Knesset, and the only real check on political power is the Attorney General and the judiciary. And the reasonableness amendment was aimed to weaken precisely these 2 bodies. And I think the judgment, I find it quite convincing, but we also need to read it against the backdrop of the entire judicial overhaul. Because if the court would not intervene or had not intervened, then the government would have been able to get rid of the Attorney General, to get rid of important gatekeepers, to get any decisions they want whatsoever, regardless of how unreasonable they are. Just think, I don't know, Itamar Ben-Gvir now saying, assuming, let's say he says, anyone can get weapons, even kids or babies, or even kids, anyone can get weapons. The only way to stop such a decision is through the reasonableness doctrine, to say that this is an unreasonable decision. We have no other doctrine that could stop it. All right. So this is just to give you an extreme example. So against the backdrop of the entire judicial overhaul, and having in mind, I assume, what would have happened if the Knesset would have absolute powers, it is extremely crucial that the court has adopted this decision. And Ophir asked whether it also strengthens democracy. So I will say this, for sure it strengthens the judiciary. I think, and I believe that it, of course, it strengthens our democracy, because democracy is not only the will of the majority, it is also the protection of the rule of law, of separation of powers, of fundamental rights, and it is the very idea of limited government. And this is what this amendment does. Of course, we have to be honest with ourselves. This is not really a decision that is completely easy. Giving the judiciary, giving the judges the power to strike down basic laws, in a way gives the court the final word. It turns the court or the judiciary into the final arbitrators of society's values. It's not an easy thing. Now, in the US, when you need 2/3 of the legislators and then 3/4 of the states to ratify an amendment, it would really seem unlikely to give the judiciary the power to overrule such a process. But in the Israeli case, when 2 Knesset members can enact in a single day a basic law, regardless of how problematic it is, then I think that this is really a necessity. It's a necessity for our democracy, as long as we don't strengthen other checks and balances. So let's assume, hopefully, the next government or the next Knesset would be clever enough to once and for all enact basic law legislation. This is the chapter in our constitution that is missing, that would once and for all regulate the rules of the game and will say how basic laws should be enacted. Let's say a supermajority of 80 Knesset members, okay? Then we would expect for, let's say, a weaker role or a smaller role for the court to intervene. So as long as we strengthen other mechanisms, only then we can weaken the judiciary.
And that brings me to another question. Or some thoughts. So over the year, I mean, many of us in the U.S., Jewish, leaders and others, try to convince the government that maybe there is a need for reform in the judicial system, but it's not to weaken the independency; it's actually to strengthen democracy, right? And I think that you were one of the people that actually try to work with, I don't know if it was with the president or with other forums, to kind of like get more people behind it. And just to remind, the reasonableness doctrine was the only law that was left out of the whole revolution that Yaniv Roznai wanted to propose on January 4th. And we will talk obviously about the power of the people on the streets, and maybe that actually helped the government, the court, to take the decision. But the basic law, the law that will define how to create basic laws, is that something that you would say it's high priority on the next coalition that's supposed to get to a decision together with the opposition, right?
Yeah. So okay. So maybe we'll start according to the order of the topics. So first, I think maybe I should have said it earlier. This judgment is, 100% totally the responsibility of the government. The government, now they say, oh, we don't want such a judgment that would give the court such powers. The government and the coalition, they had dozens, hundreds of opportunities. And I'm saying it because I was involved, as Ophir mentioned, in some of them. Hundreds of opportunities to enact a much more reasonable amendment, if I can still use this word, a more balanced reform, a more relaxed or nuanced reform. And even people who do not support, judicial activism, etc., they proposed various proposals in the weeks before the enactment of this basic law. Sorry for that. Whenever I talk about the judicial overhaul, my dog starts barking. And the government, at every single opportunity that they had to reach to some kind of a compromise, they rejected it. So really, it's people ask me if I'm happy because of this judgment. On one hand, I'm happy, but on the other hand, I'm a bit sad because we could have avoided the government if it had only worked, a bit more gently, in a more clever manner. They could have enacted a more balanced amendment, and then the court would not interfere. And which brings me then, let's say, to some of the discussions we had. So just to give you like a broad timeline, if you remember, in January, Yariv Levin proposes his proposal. They start this blitzkrieg in the Knesset of very quick and hasty legislation process. Throughout this time, me and many other colleagues, either from the civil society, various research centers, academics, we all sat together with various groups from all sides, tried to reach various compromises to try to get to some kind of a more, balanced formula. I do not object to reforming the judicial system. I think that any governmental system needs a reform. In the education system, we need a reform. In the health system, we need a reform. And also in the judiciary, in the judicial system, we need a reform. But we need a good reform. We need a balanced reform. We don't want something that would completely destroy the judicial system. We want something that would improve our systems and our democracy. And really, we've put, I do not graduate, I'm not a graduate, thousands of hours in negotiation, trying to solve this crisis. None of it succeeded. And then in March, the president of the state, after listening to various groups and scholars, proposed his version. And again, this is dramatic. I remind you, we are not the US. We are not a presidential system. The president doesn't have any formal role or capacity in that respect. Nonetheless, he understood how major the crisis is, and he spoke to the public on national television, and he proposed the constitutional reform, the president of the state. And this proposal was rejected 7 minutes after it was proposed. Now, I've read that proposal. Trust me, it takes more than 7 minutes just to read the reform. So this was a shame. And then from end of March till end of June, the coalition, together with the opposition, sat together under the auspice of the president's house to try to reach to some kind of a compromise. And I was a disclaimer, I was involved. I was a consultant of the opposition parties, and we all came, in good faith to try to reach some kind of a compromise. It was rejected. It was very difficult to reach a compromise. Now, trust me, if Ofir and I and Galit, we sit together, together with 70 or 80% of the Israeli people, we can reach a broad consensus. Okay, it is the 20% of extremists, perhaps even of both sides, who are the obstacle. And this brings me to the future, and if I think that a better reform, one that will be enacted hopefully in a consensus, is even possible. So let me start by saying yes, and I know it from different talks with different politicians. They all understand that whatever we had in the past cannot continue. We need to use this constitutional crisis that we experienced as a constitutional moment, because after all, we had mass mobilization of people here, hundreds of thousands of people talking about high politics, democracy, rule of law, rights, judicial independence. This is not the everyday politics of the Friday morning parliament in the coffee shops in Tel Aviv. No. And we need to use this constitutional moment as a moment to, in a way, establish a better constitutional order, to improve our democracy. And what we need in order to do that is at the very least, two things. First, we need this basic law legislation that would make a distinction between everyday politics and constitutional politics, because now the legislators, the Knesset members, they wear two hats. In one hat, they are ordinary legislators. In their other hat, second hat, they are members of our Constituent Assembly. It doesn't work together, because members of the Constituent Assembly need to consider broad considerations, long-term considerations for future generations. And ordinary politicians consider ordinary everyday politics. They have a conflict of interest. How can they do that? So we need to make some kind of a distinction between these two processes. And we need to regulate the relationship once and for all between the judiciary and the political branches. We need to provide the manner by which the court can review laws of the Knesset, how it can strike them down, what could be the possible political reaction to such declaration, etc. So this is basic law legislation. The second thing that we need, like any other normal democracy, a Bill of Rights. How is it possible that in 2024, Israel doesn't have the right to equality, free speech, freedom of religion or from religion in its constitutional document? It's embarrassing. It's unthinkable. So the second thing that we have to do, and these two things have to come together, is to finalize our Bill of Rights. The liberal camp for too long has been silent. It has, in a way, suffered from various compromises, mainly in the areas of law and religion. And I think this year, that was a year of awakening for the liberal camp, must be the opportunity for a better regulation. But again, I'm not saying that one side should win. No, not at all. We are one nation. We are all brothers. We all have the same external enemies. We need to find a way to reach to an agreement and to put the energy and focus on what really matters, which is peace and security, and not the reasonless doctrine, with all due respect.
So I will add on that, that again, even during the protest, that millions of people took the streets. I mean, every poll showed that 80% of the people are against this judicial overhaul as it was proposed. And when we say we are all brothers, we still know that the government is still run by the same people. We need to be very alerted because there are still extremists running the government. And we can see also from their post, we are not celebrating this judgment, but they are definitely looking for the next fight. I mean, we saw some very nasty announcement by politicians from the Ben Gvir party and others. So when we say we are all brothers, I think that what we should be very clear is probably is that again the watershed during the protest movement was clearly between what we called liberal Democrats, people who believe in Jewish and democratic state, and the people who want to try and overhaul and get more power. So we have to work together. And I think that one of the things we have seen, and that's maybe a segue, that we have seen the Jewish Americans and the Israeli expats joining this effort and probably finding their brothers and sisters who are actually fighting for democracy, because we know that we are before election system here as well, and democracy is on the crisis on both sides. There is a question that coming, if we think about U.S. politics. I mean, a question that came is it a question from Linda Clifton? Is a new decision similar in Israeli history to the Marbury vs. Madison in the U.S.?
Okay.
So and maybe you can elaborate for those who doesn't know what is this.
I'll explain. So Marbury versus Madison is one of the most famous U.S. cases from 1803, and in this case, actually, the U.S. Supreme Court held that it has the authority of judicial review, so it has the authority to strike down laws that would go against or violate the Constitution, because the Constitution, the U.S. Constitution, doesn't provide explicitly for such an authority. So the court had to read it implicitly from the supremacy of the Constitution. So I would have to say no. It's not like the Marbury versus Madison, because we already had our Marbury versus Madison 30 years ago in a famous case called the Mizrahi Bank case. Back then, it was considered quite a long judgment, about 400 pages. Now it's really, it's a kinder. It's nothing. It's Pitzkala Gergely compared to this 740-page long judgment that we have. And already in that judgment, the court said that it has the authority to strike down laws. The uniqueness of this judgment, that the court now has the authority not only to strike down ordinary laws, but also basic laws. Now, again, this is not something that is completely new in a global level, because we have courts around the world, for example, in India, for example, in Germany, for example, in Brazil, or in Colombia, where the court also has the authority to strike down constitutional amendments. But I want to highlight something that Ophir mentioned. So some people might think, okay, good. Now we are relieved. We can lay back. The court said that it can protect our core democratic values. That is it. We won the battle for democracy. No, of course not. Because those who pushed, not all of them, but many of those who pushed for judicial reforms, their entire raison d'etre, their whole reason for political existence is reforms in the judicial system. They have nothing to propose apart from that. And they will continue to push for that. And some of them do it for ideological reasons. And I already heard this morning some members of the coalition who say, aha, we told you, see, look at this judgment. This is precisely why we need a constitutional reform. This is what we were trying to tell you all this last year, that the court is too strong. Now they proved it. So I think in a way we need to be aware that this judgment can fuel and give ammunition to those who want to attack the court. That's on one level. On the second level, look at what this judgment is actually doing. This judgment is giving the court, the judiciary, enormous powers. The powers to override constitutional norms, constitutional provisions. Now, because the judges are now stronger than they were before, this actually gives more incentives to the government to capture the court, to replace the judges with their own judges. Because now, with this tool in their hands, they can not only, strike down administrative decisions, but now they can also strike down basic laws themselves. So I think even more than before, we need to make sure that we protect judicial independence and we make sure that the judges are not captured by the government. And the third and last point in that respect, this judgment only speaks at the constitutional level. What if the government would bring now a constitutional reform that is really problematic? But sometimes we can do very bad things, not in the constitutional level, but in the lower levels. When Erdogan tried in 2008 to amend the constitution, and there were two amendments that infringed upon the principle of secularism, the Constitutional Court blocked him. And then he tried to do a referendum for a new constitution in 2011. It didn't work out for him. So what Erdogan did in Turkey, he simply did some of the plans that he wanted in the administrative level. He simply replaced various personnel with his own people. And for this, we have no judicial cure in this judgment. So we need to keep our eyes open. We still need to be alert. The risks to our democracy still exist. They're not over. But I do hope that our politicians will take the main theme song of this judgment, that is, constitutional reforms you do in a consensus.
Yep. I want to actually remind us all that we are still in war with Hamas. And one of the key elements of the protest movement was when the brothers and sisters in arms basically raised the cruciality of the judicial independence when it comes out to any risk to Israeli soldiers being accused in war crimes. Now, it's not about arguing now, are we doing a war crime, are we not doing a war crime? It's not the question. The question is, what we hear more and more is that the ICJ is the international court.
Yeah, the ICJ, the International Court of Justice.
ICJ. And the maybe you can talk more, right, about this decision and how it reflects the judicial independence and how it might reflect on the ICJ decisions.
All right, perfect. So I think we need to maybe make a distinction between two things that are going on. So let me start with what we call the ICC, the International Criminal Court. This court, again, it's an international court. The US is not a member. Israel is not a member, but it could. There are some ways by which it could get jurisdiction over Israel. This is a criminal court that deals with people, with individuals, top individuals, heads of state, high officials, generals, etc. And there is now still an ongoing investigation at the ICC. Now, the basic rule of international courts, like the ICC, and of other courts around the world who can apply what we call universal jurisdiction. So, for example, like the Eichmann trial, if I have now a war criminal, I can prosecute him or her, even though they're not, related to my country. This is universal jurisdiction. So, the only way to counter universal jurisdictions or jurisdiction by international courts is what we call the principle of complementarity. What does it mean? It means that other courts will only have jurisdiction if the national court is unable or unwilling to prosecute those who are suspected let's say, in war criminals. Now, the more independent our court is, the more independent our attorney general is, the more independent the legal advisors to the military are, then there is less of a chance that we will get prosecuted abroad, and vice versa. If the weaker the court and the legal advisors are, then the stronger the chances are that we will get prosecuted elsewhere. And the reason is important in that respect because it is another mechanism for the judiciary to supervise governmental actions, including doing military operations and doing wars. So I think in a way the reasonist doctrine assists in protecting IDF soldiers. This is crucial. Now, I'm putting the ICC aside for a second, and I'm moving to the ICJ. That's the International Court of Justice. This is the most distinguished international tribunal in the world. It deals with countries, not with individuals. Now, a few days ago, South Africa has submitted a petition to the ICJ against Israel for the crime of genocide. Now, unlike the ICC, the ICJ apparently has jurisdiction over Israel because of the Genocide Convention, to which Israel is a party. So they have jurisdiction. And usually the most problematic thing in these type of cases is to prove intent. Okay, these guys over there are doing horrible stuff, but do they really have the intent of a genocide? Now here, and I'm saying it in a very critical approach, here our government really played to the hands of those petitioners. Because if you read the petition, if you go over the petition of South Africa, and South Africa, they know what they're doing. They have some serious jurists there. They have collected various phrases and sayings by members of the Knesset, by ministers of the government, speaking about we will wipe out Gaza, we will remove from the earth Zera Amalek. There are no innocent civilians and everyone should be targeted, etc., etc. Really awful statements and stupid statements that now serve countries that are against Israel to show, aha, look, here is, now we can prove the intention. Now, then you as an Israeli, try to explain them, no, the Minister of Intelligence, she doesn't really have any real standing. No, that minister, they don't really mean anything, and we don't count them. They just talk to the base. How can you explain it? How can you justify it? So instead of understanding that words have meanings and that we are doing wartime, and to watch their mouth and not say really stupid things that could be awful in terms of the implications to the entire country. Because I don't want even to start imagining what would happen if the ICJ would give a judgment that Israel has committed a genocide. I hope we don't get there. But even in the meanwhile, the ICJ can give some kind of an interim order telling Israel you have to cease fire. Why would we want to do that? And look, this is not the UN Human Rights Council. This is the ICJ. It's a serious tribunal with serious judges, with extremely high reputation. It would be very problematic, this area. Now, I think that once a country is adjudicated in the ICJ, it has the right to add a judge to the tribunal for that case. And I didn't really get a chance to read because I had to run from different lectures, but I just skimmed through and someone sent me that now the government is saying, oh, maybe we should bring Alan Dershowitz as a judge to the ICJ. Now, of course, Alan Dershowitz is a huge name, a huge jurist. But I think that if the state of Israel needs to choose a jurist that will defend the Israel, and will be able to convince other judges, I'm not sure whom would be the best person to do that. But we need to think of very serious names who have also expertise in international, who have judicial reputation, perhaps. Maybe something, along the figures of Aaron Barak, that if you'll say something, other judges in the court will listen to, or Dorit Beinish, the former president of the Supreme Court, something like that, or really someone who is a world expert in international law, like Yuval Shani, a famous jurist who the other judges will appreciate what he or she are saying in that respect.
And again, I mean, that may be a good example for a reasonable decision that is not again, we all know that Dershowitz is probably a very good friend of Netanyahu and loyal and et cetera. So again, this is where reasonableness is in a way coming to the game all over the place. And that's super important. So I think that again, I mean, like, just to close the loop, the decision of Bagatz, of Supreme Court yesterday was taken as a big decision, 12-3, that is allowing to cancel at least 12, as you say, and maybe 13, is allowing to cancel a basic law, and 8 of the 15 plus 3 that was looking into. So there is a clear definition of like consensus, almost like a very big majority doing that. Now, there is a question from the audience and saying, like, maybe we didn't mention it, but the reason that the decision was taken yesterday, or it should have been taken until the January 12th, is because 2 judges, Esther Chayut and Baron, is leaving the court, and what's happening now with decision of new judges? Like, is the court ready to take new judges like in the US and maybe overturn the decision?
Yeah, that's a good question. So let's say 2 liberal judges, right? The Supreme Court President Esther Hayut and Justice Baron. They both retired in middle of October, and this is why we had this deadline of middle of January. So now we have 13 serving judges at the Supreme Court. There are vacancies. There are vacancies, but the Ministry of Justice is unwilling to appoint judges because perhaps he still has some kind of dreams of changing the manner by which judges are selected in Israel. I don't know. But let's assume even if we have 2 new judges, in order now to overrule this precedent, what you would need to have an en banc 15 judges sitting, and you would need to get a majority of over 12, let's say, that would say, no, actually, we don't have the authority to strike down basic laws, and I don't see it happening anytime soon.
Okay. And again, quick reminder for those, I mean, one of the judicial overhaul that Yariv Levin was pushing for is to change the structure that it's choosing, again, taking political, making sure that the coalition will have the majority in this committee. Luckily, I mean, not luckily, with a lot of work on the people on the street. So let's just take this question of the people of the street, like the protest movement. What was the influence of people on the streets on this decision, in your opinion?
Yeah, that's a terrific question, I think, to close with, because the court is strong, the court is independent, and I think that the court has reached the right decision. But the court is not the hero here. The court is not the only actor. The court needs other actors in order to protect democracy. And here I think the people were crucial in at least 2 or 3 aspects. For one, it is only thanks to the people that we've managed to block other parts of the reform. There were other really problematic proposals that were blocked along the way. So the fact that they were not enacted, it is only thanks to the people. Second, I think that the court, of course, the court needs to make judgment only according to law. But I think, it is, I'm, in a way, I want to believe that the fact that there was this huge support behind the court, that perhaps, gave the court some more, let's say, courage to do that. Perhaps, I don't know. This is, being a judicial psychologist, trying to see how judges think in a way. So I think the people were crucial. We usually talk about, different branches of government. We talk about 3 branches, the legislature, the executive, and the judiciary. I think that the people of Israel have proved there is also a 4th branch, the people who can serve as an institution for protecting democracy. And that is something that I hope that, you guys, you expert all these high-tech stuff. I hope that this is something that we can also export to the rest of the world, because there are various countries there, various democracies who deal with democratic erosion and populism, and perhaps they will get some kind of an inspiration from the Israeli story.
Thank you, Yaniv. And just I'm going to read one of we put yesterday a statement from Unacceptable. I mean, like, to say like that basically, as we said, it's not really time for celebration. We still have 129 hostages that are still held by Hamas, 10 of thousands of soldiers fighting in Gaza, and hundreds of thousands of citizens from Gaza perimeter in the north are still refugees. So it's definitely not a time for celebration, and it's definitely also a moment to know that the responsibility of this government to the status that we got into, I mean, and the danger that it represents, as we talked about, the risk to democracy. And so it's our patriotic duty to continue to demand different leadership, and that's bring us again to the core of the next conversation that we are going to have with Dr. Tomer Persico about response, because as we said, I mean, we maybe saved the day for the democracy, but it's definitely still at risk.
When are you meeting, Tomer? When are you meeting him?
On Thursday, 11 a.m. Pacific time. Again, we're going to talk about the crisis in Israel and the influence on Jewish diaspora, and obviously the anti-Semitism that we see here and our role in response to that and to the democracy crisis.
Amazing. Guys, those of you who listen, I highly recommend it, and please join and listen to Tomer Persico, who's really an impressive scholar and thinker. He's also a Rubinstein Fellow, I have to say that, in my institution, so I'm not very objective.
Yaniv, thank you so much for joining us in such a short notice. It was inspiring and so much information that we need to process. Thank you, everyone that joined on a short notice to the conversation. Again, keep looking into our notes, mailing list, etc. And we must hopefully see bring them home now, the kidnapped people that by Hamas, and we have a lot of work to rebuild and restart Israel. So thank you, everyone, and I'll see you on Thursday.
Thank you very much.